And I am going to, when we are done, I am going to ask for permission to read the letter to this committee.
All right,
So
no,
we
that's
can
fine.
stop playing games.
No, the letter is before the committee. I'm just.
Yes, but I would like to read it for everyone who's listening so that the auditory.
You are here to answer questions, please. I'm saying I've just read you.
I am losing time for every word I utter. So as professionals, we also have to be self-regulating about what we ask and what we discuss without waiting for the chairperson to tell us.
In the spirit of give and take. No, anyway, you're wrong, madam. I'm not paid for every word I utter, but I forgive you for that because you wouldn't know, but that's fine. I was simply saying that in terms of the directives of this particular committee, the final arbiter, for better or for worse, is the chairperson of relevance. I'm just informing you.
It must be for better.
Probably for better, yeah. But not always. I'm informing you. All I was asking is whether you understand that. I'm not debating the point with you. It's in the directives.
Yes, but if I think you're asking me an irrelevant question, I will say so, sir.
Okay, so let's wait until that happens. For now, I'm just asking you if you understand.
I fully do, sir. Thank you.
You do. Thank you. That's better.
My answer is yes. There was quibbling about. No. You don't cut me like that, sir. There was quibbling about that, but in my earlier statement, please don't talk over me. In my earlier statement, I had also indicated that you compacted the quibbling to those two matters, yet the real confusion was around whose inquiry is this? And all of those vague statements where you say, oh, courts have made these remarks about your cases. What is your comment on that? So I wanted to know, number one, am I being investigated now? And two, which cases? Must I go all over the internet to find out what have courts said about my cases? And three, I specifically mentioned to you that as far as I know, no court has accused me of not understanding the Constitution or being dishonest.
Okay, ma'am, can I ask you to please firstly listen to the question and then just answer the question that is asked of you. Then we will get somewhere because on your theory, I don't only get paid by words I utter, but even the words I listen to. So let's not make them too many. I'm asking you a very simple question, that in response to your invitation for us to indicate which other areas other than CX that we needed answers to. Number one, we indicated to you that the other issue is Friede, because that's common cause that was from the chair. That's what we did at paragraph 6 of our response, correct?
Yes.
Thanks. Now we're getting somewhere. And then the other issue where we corrected you was to say that it is false to state, as you stated in your statement, that the public protector's team had, quote, forbidden the evidence leaders from assisting you with a statement. And we said, please indicate to us who advised you of that non-existence fact. That was the second issue that we raised in that response, correct?
Yes.
And as it happened, the Secretariat, I think, without our knowledge, had also sent you a letter indicating that that allegation was incorrect, right?
Yes, sir.
Thank
That
you.
was my mistake, which I admitted.
Yes, and which you apologize for, which apology was accepted. So
And which you dealt with last week and you're dealing with again today.
Yes. To what, did you give evidence last week?
Well, it's on the record.
All right. Okay. Anyway, so at least we settled the fact that it was at your invitation that we indicated those areas. Good. Now let's come back to this issue of the statements. You were aware that
I'm sorry, sir. With your permission.
Yes.
You see, giving answers out of context.
With the chair's permission.
With your permission, Chairperson,
Yeah.
can I just clarify that Advocate Mkhwebane, let's not mislead the committee by narrowing. If you're going to quote that letter, put the whole letter on record. Because yes, it was at my invitation, but in response to your previous letter, where I was saying I am confused about all of these matters that you have raised. And this is what the chair says I should do, and you are saying I must do something else. And you ended up actually providing new issues instead of clarifying my question. So it's important that we give those who are going to judge this matter context and not be selective about the evidence we put on record. Firstly, at that stage, I didn't know who Mr. Siabi was.
No, I'm not there. I'm talking about 7.3 now, ma'am. Relevant human resource issues and policies. You've already answered the Siabi Nyatela issue. I'm saying relevant human resource issues and policies regarding the security clearance issue. Did you regard that as putting you under the bus or not?
I'm going to latch on to a footnote. Surely you didn't come to this event prepared to latch on to a footnote. Can we deal with what we came for?
Can you please answer the question, Advocate Madonsela? Or do you want me to ask it for the third time?
Well, okay. I don't know. Because the questions were vague, I had no idea whether the intention was to put me under the bus or not.
Oh, I see. So now you didn't know whether it was the intention. I thought you said that was the intention. Okay, that's fine. And then the next one was
on the record, it would say differently.
All right. And then the next one we said we'd ask you on governance issues and audit outcomes. Do you regard that as putting you under the bus?
I regard it as irrelevant.
But not putting you under the bus?
I'm not sure, depending on what was intended with it. Anything that was vague was potentially trying to put, not putting me under the bus, trying to.
I see. And then the next one was the management of backlogs and other performance challenges. Under the bus?
I don't know.
Don't know. The next one was scathing remarks made by the courts in respect of some of the reports issued during your term. Under the bus?
Irrelevant, sir.
Okay, but not under the bus. Then the next one was the impact of especially the EFF versus Speaker, the Nkandla judgment on the frequency of court challenges and the spend on legal fees, as well as clarity on the question of which version of the Executive Ethics Code you applied in respect of the Nkandla investigation and others. Under the bus?
Irrelevant. I am going to, when you are done, I am going to ask for permission to read the letter to this committee.
All right,
So
no, that's fine.
Stop playing games.
No, the letter is before the committee. I'm just—
Yes, but I would like to read it for everyone who's listening so that the auditory—
You are here to answer questions, please. I'm saying I've just read you the 8 issues which we gave to you at your invitation, and none of them seem to be putting you under the bus, or you don't know whether they put you under the bus. That's fine. That's let's leave it at that, and let's go to the statements now. The affidavits, or so-called, okay, let me put it this way. And this is the context I wanted to put to the chair before. The reason, madam, that we offered to assist you with a statement, as we do with all witnesses, and as evidence leaders do with other witnesses, is because we are, as you know, trained to do this. We do it almost day in, day out. And quite frankly, whether you were going to do it with the evidence leaders or us, wouldn't make much difference, except that it would simply conform with the requirements of the law and the requirements of this committee. So let me just make it clear.
What response to that?
No. Okay, let me context. Yes, you'll have your response, but let me contextualize what I'm saying. Your first issue was that the reason why you rejected our assistance was because there were things that put you under the bus, which turned out not to put you under the bus. I'm now telling you the reason for offering your assistance was not to put you under the bus, but simply for you to be assisted as somebody who might not be conversant with the practice of law and how these affidavits should or should not be done. That's all. That's really why we assist all witnesses. And
can I have a response to
I'll
that,
show you just now that you actually needed the assistance. Yes, you may.
And that affidavit was replaced by one that was sent on the 28th. You didn't object to that affidavit. You had a whole week to say that's not an affidavit. To come now and decide that you're going to spend taxpayers' money arguing about whether the document of the 28th is an affidavit or not is shocking, to say the least. But anyway, no, well, it's the park protector that's paying, it's not me. So maybe I shouldn't be dealing with that.
Yeah, maybe not, ma'am. But
as a taxpayer, it worries me.
Yeah, no, that's fine. Well, as a taxpayer, it also worries me when it looks like there's a crime that is committed.